for rebuttal.
Yes, Your Honor, I'd like to reserve 5 minutes.
You got it. Please proceed.
May it please the court, my name is Bethany Schneider and I represent the appellant William Nelson. We are seeking reversal of the trial court's order granting appellee's motion to dismiss for improper venue. The issue before this court is the peculiar proposition that a Florida corporation that is a family-owned investment company whose officers owners live in Florida, with its business mailing address in Florida, with a registered agent in Florida, and a registered office in Florida, cannot be sued in a Florida state court because the tort occurred elsewhere. The question for this court under the statutory language is, can the homes of the officers owners of a family-owned business or the business's mailing address be construed as an office for the transaction of customary business for an investment company who has an asset outside the state where the tort accrued?
So Ms. Schneider, to just kind of cut to the heart of it, you use the air quotes, so I'm going to hold you to it. The legislature has not updated the venue statute in some time. Clearly, the provision that deals with venue for domestic corporations contemplates a time back when brick and mortar offices were du jour and were far more common. Those days are different than they are now, for sure. Why isn't a reasonable answer to the peculiarity that you raised to call your legislator and tell them, hey, it's time to update the venue statute? But we as an appellate court and the trial court below have to work with what's there. And we are not at liberty to supply air quotes around terms like offices if the common parlance would understand an office to be a brick and mortar building. Can you help me out with that?
Yes, Your Honor, you're certainly right. However, when this interpretation of statutory language would lead to an absurd result, you can look beyond the four corners of the statute into what the intention was behind the statute. And of course, the intention behind the statute in 1869, when the statute was first written and drafted, was that an office was to be seen as where the corporation's home county is. And at that point in time, Your Honor is exactly right, that the notion of conducting business was only out of an office building, a brick and mortar office building. But we do have the Tribune case that was in 1959. And back then, there was still even this notion of the brick and mortar office. But the Tribune case does address how this office definition can be expanded to actually look at where the corporation is actually present, where the members of the corporation actually exist. And in this day and age, when we have so many companies conducting business outside of their homes, the notion of an office, if you go to what the legislature actually intended it to be, which is that corporations shouldn't have to leave and go far away to a distant venue, to be sued. Rather, they could be sued right there where they were at home. And the Tribune case does talk about how that, even in 1959, back when it was, when it was written, that this notion of an office would need to be updated as technology was updated. And so here we have the owners of a family-owned business who list their home address as their address on the Secretary of State's website, and who list the fact that their business mailing address is a P.O. box all in Pinellas County, that their office can be construed as a home office, because presumably they would have computers there, they would have printers there, and contrary to the argument made by the appellee, conducting business of an RV park could be done from their home, which would act as an office, right? They could do online reservations and payments. They could coordinate with the on-site employees. They could do all of those things online. And just because it's their home doesn't mean that they're not the same as a lot of people nowadays who have their home offices. And so the affidavit that was submitted by Ms. Welch was a very cleverly worded affidavit, and it only focused on this term office. It did not say, as the trial court interpreted it to say, or as the appellee says, that they conduct no business in Florida. It focuses on the terms office and employees and equipment. And so we are left reading the affidavit that there is not a statement that they don't conduct any part of their customary business through their homes or through their business mailing address. And leading the result of being that basically if they don't have an office in the state and the tort occurred elsewhere, that a plaintiff could not sue a Florida corporation in Florida runs in direct contrast to the United States Supreme Court decision in Bristol-Myers Squibb and other decisions before that, where they say as a matter of due process, plaintiffs must go to the defendant's home state. And that here it seems curious that now appellee Jamar is saying, no, we don't want to be sued in our home state. Take us to a place outside of our home state when our homes where we run the business are 6 miles from the courthouse.
Well, you're making an assumption there, though, in what you just said. You're making the assumption that that's where they run the business from. And from what I can tell on the record, just as it stands, there's no indication that they actually run any business out of their homes other than, making sure they've got their filings with the Secretary of State up to date. But their customary business, I assume, is not merely making sure day to day that the corporation still exists. So right now, as it stands, and I know that you had the request for discovery in your response, and I know there was no evidentiary hearing, but as it stands right now, the only thing we have in the record is the officers live in Florida and there's a mailing address in Florida. We don't really know anything beyond that. Is that correct?
Yes, Your Honor. But it is the defendant's burden to conclusively prove in the trial court that the venue is improper, and they have not done that. While there's not necessarily evidence in the record that they do conduct any business through their home, we do have to remember and separate that the business is separate from the actual RV park. So the business that we're suing is an investment company. It's a family-owned investment company, according to the affidavit of Ms. Welch. And of course, we know that the definition of family-owned has to do with the fact that the company or the corporation is owned or controlled by a family. So presumably there must be something that the family is doing to run their investment company, and their investment or their asset in this, case is this RV park in North Carolina. But again, if we go to the actual affidavit that was submitted, there is no statement that they don't run business from Florida or that they don't do conduct any customary business in Florida, because all it says is that they don't keep offices within Pinellas County, Florida, and that the employees that they employ to transact the business work in Hendersonville. Well, we know, though, that 3 of the employees would be the officers of the corporation, right? And all 3 of those people live in Florida, and the business mailing address is in Florida. So anything that's sent to the business would have to go be picked up in Pinellas County. So certainly there's got to be some business that this investment company is running in Florida. Also, we don't know whether they have other investments that are in Florida that they're perhaps running as well. But it was the defendant's burden to prove conclusively in the trial court that it was an improper venue. And the court decided the opposite. They said that the plaintiff had not proven that it was a proper venue. And that was the wrong decision to make, that there obviously needed to be more information if the court was going to conclude that the venue was improper, because the court made the factual determination that appellee Jamar does not transact business in Florida as part of its usual ordinary business. And that factual decision is not supported by the competent substantial evidence. It is not supported by what the actual affidavit says. The affidavit only addresses the actual word office. And so I want to go to I'm sorry.
I'm sorry, I was going to ask you, you noted in your brief that apparently the order came down on this motion without convening a hearing pursuant to an administrative order in Pinellas County. Can you expand on that insofar as that touches on your argument about evidence here?
Sure. I mean, we got this notice from the court after we had asked for discovery on the issue that the court, found this to be a non-evidentiary motion. That Pinellas County had this order that you can decide it without a hearing after originally a hearing had been set. So of course, now we're thinking, well, obviously on the papers, we presented enough evidence to show that this is, if it's not going to be decided on evidence and it's just going to be a legal determination, then the court was just going to decide it without having to make any factual determinations. But that's not in fact what the court did. And as I said, the court did make the factual determination that based on just the self-serving affidavit, not subject to cross-examination by Ms. Welch, that the appellee does not transact business in Florida as part of its usual ordinary business. I did want to go to make sure I don't run out of time. I did want to go to talking about the 2018 5th DCA case of Subic Bay Marine Exploratorium Inc. versus JB China Inc. 257 Southern 3rd 1139. While that case is not exactly on point as it focuses on personal jurisdiction, I do think that it is instructive here. Because in Subic Bay, the defendant JB China was incorporated in Florida. Now, like Jmar here, by looking at the Sunbiz entry, its principal place of business was outside of the state in California. But unlike Jmar, whose business mailing address is in the state, JB China's mailing address was in China. Also, unlike Jmar, whose officers reside in Florida, JB China's officers resided in California. And there, the 5th DCA said that the case could be brought in Florida. Now, while this addressed personal jurisdiction and not venue, it is instructive that the court didn't go on to say, well, although personal jurisdiction, they would have personal jurisdiction, once we get down the path to venue, then there's going to be a problem here. And even when the case was actually remanded, it was voluntarily dismissed without prejudice based on other grounds having to do with the merits, and no motion to dismiss for improper venue was filed there. And so I think that is instructive that there are situations where this has come up and that has not been addressed. Obviously, every case that has been addressed by both sides has been one where there's a decision between either two or more proper venues, and it's deciding which venue to transfer it to. This is an issue of first impression, as far as we can tell, where a Florida corporation would say, because of the strict construction of the statutory language, we are not subject to any venue in this court. And that is an absurd result when there's obviously personal jurisdiction and even a preference for having defendants being sued in their own home state. And so because of that, the term office can be seen as a home office or somewhere where other business is conducted, like a business mailing address. And that we don't necessarily have to just go to the legislature and ask them to change it. Certainly the 2nd DCA has expressed frustration with this statute before in the PricewaterhouseCoopers decision. And so it may be time for the statute to be changed, but I don't think that limits the ability to maintain venue in Pinellas County here. And I guess I'll reserve unless there's other questions.
What exactly is the remedy that you're seeking? Do you want just straight out, are you asking for straight out reversal of the order, or are you asking for a remand for the discovery that you had asked for and or an evidentiary hearing? Because you just say dismissal in the brief, so I just want to be clear.
Yes, Your Honor. Thank you for giving me the opportunity. Yes, we seek a straight out reversal and remand to Pinellas County. While obviously we think that there should have been an evidentiary hearing and the opportunity for discovery, we believe we would be right back here if that were to happen, because the same question would be before the court, whether you can interpret this statutory language of office more broadly to encompass a place where there is transaction of customary business versus having to have kind of a brick and mortar physical office.
So well, the issue might boomerang back, but would you agree that on a limited reversal and remand on that basis, there would be an opportunity to develop and get a better record to handle some of those things that you mentioned earlier in your argument about presumably this happens, presumably that happens. We or whatever panel would have to address that, or the trial court for that matter, would have the benefit of developing, what actually is going on, what kind of business are these folks going on, and then figure out from there, okay, does the statute's use of the word office, can it encompass these discrete facts?
Certainly, Your Honor, and that would be, enormously helpful. I think what would be even more helpful, basically kind of a combination of the two, just to preserve judicial efficiencies, is maybe for some guidance on what the statutory language could encompass and whether this court would find that it should be narrowly construed versus, a more broad, more current version. And maybe, then, with that direction, then perhaps being remanded if this court thinks that there should be more of a record developed, so that there is some guidance, so that we don't have to kind of boomerang back, as you said.
Fair enough. All right, if there's no further questions, Ms. Sisti.
May it please the court. My name is Diana Sisti. I represent J. Miller Investment Incorporated. For the remainder of the argument, though, I will be referring to my client as Jmar Travel Park, which is its DBA. As a preliminary issue, I just want to mention there's absolutely no record evidence or any indication that my client is an investment company. To the contrary, they're doing business as is Jmar Travel Park, and the plaintiff's complaint alleges that their business is operating, maintaining this RV park up in Henderson, North Carolina. And I think that's important to note, because I think a huge portion of Ms. Schneider's argument dealt with the fact that this is an investment company, and that there's just no support for that. What it comes down to is that the statute specifically prescribes 3 different alternatives for venue, and those alternatives have been litigated extensively throughout its inception, and nothing that that is presented in this case would warrant any type of change to that. And to the contrary, in this case, for these facts, Florida courts, if anything, have an interest in not hearing a premises liability action that occurred in North Carolina in the state of Florida, especially with the dockets being as saturated as they are.
Isn't that more of a forum nonconvenience argument, though?
It absolutely is, but I think
that's not. We're not at that point.
No, I agree, but I think it is worth mentioning. So getting back to what the law actually is, the law, Florida Statute 47051, has those 3 places that a lawsuit can be brought against a Florida corporation, and those encompass many cases. And it's when either the action accrued in a specific county in Florida, if the property subject to the litigation is in Florida, or if they have an office. And it's not just an office. And this is a huge distinction that I think is missing from the appellant's argument. It's not just whether there's 4 walls with a computer that someone actually has an office. It has to be an office where they regularly conduct the business of that company, not any business, but the business of that company. And,
let me ask you this. And this maybe goes to this probably tangentially, it's on your point about it, whether it's an investment company or a travel park company. But the statute says it's customary business, and the antecedent to that pronoun is the domestic corporation. So the domestic corporation owns, let's say, multiple travel parks or various going concerns that do various and sundry things, and goods and services. The statute says in the office, the customary business that needs to be conducted is that of the domestic corporation. So, it's not necessarily the case. Correct me if you think I'm wrong. It's not necessarily the case that if a corporation owns a business, that businesses customary business doesn't need to be conducted in the office. It's the domestic corporation's customary business. That's a way of reading the statute. I was interested in your take on that.
To be completely forthright, I did not think of it that way. And the reason that I've never, I haven't thought about it that way is because I just don't even think that you get there. I think that the statute's so clear. And the two things that I want to get to is there are two bases that the complaint alleges allows Pinellas County to be proper. And both of those bases have been addressed by courts in the past. And the first one is that the corporate officers personally reside in Pinellas County. Okay, and in Pearson v. Wallace, the court has specifically held that it was error to find that that the venue would be proper in a place where a corporate officer resides. And saying that they're employees, there's absolutely no factual basis to even say that they're employees. I think that was addressed. And the second one regarding the mailing address is in Majestic 2, the court specifically said where there was an affidavit by the plaintiff in opposition to an affidavit filed by a defendant corporation related to where there was an office, the Secretary of State filing that had a address listed in one county as the corporate headquarters, even that wasn't sufficient to meet the statute, because it not only has to be an office, but it has to be an office where they regularly conduct the business of the corporation. And in Deerfield Import Export Incorporated v. Newton, this court, the second DCA, explained what that means. And what it says is it must be continuous and not mere occasional or isolated transaction. So in this case, the doing business is the travel park. There's no evidence that there's other travel parks. This is,
but there's no evidence because the plaintiff wasn't allowed discovery.
And there's nothing that says that they should be allowed discovery. To the
contrary. Well, the case law says that the venue is a very fact-intensive determination that should be determined after an evidentiary hearing, unless it's clear from the face of the complaint that venue is improper. And not just that it's not clear from the complaint that venue is proper, but unless it's clear from the face of the complaint that venue is improper.
Yes, and
there's a difference.
I agree. And on the face of the complaint, venue is not proper. And I say that because, again, the specific allegation in the complaint is that venue is proper because in Pinellas County, because that is where JMAR Travels Parks corporate officers reside and where the company maintains its corporate mailing office. So, or address, sorry. So that is what the complaint alleges. On the face of the complaint, they fail to establish venue pursuant to the statute.
But see, that's different. That's different because maybe the allegations aren't quite sufficient to get them there, but they don't establish that it's not there. And that's the distinction I'm trying to draw.
And I disagree. What the complaint establishes is that the plaintiff, who is a resident and citizen of the state of Georgia, was renting an RV spot at an RV park in North Carolina when he was allegedly injured from a dangerous condition in North Carolina. So based on those facts, I don't think that it was established or that venue was proper. On top of that, though, if I can point your attention to a couple different cases. The first one is Merrill Lynch v. National Bank, and it can be found at 283 Southern 2nd 665. This is a 4th DCA case from 1970. And what the court said was that it's well established that an evidentiary hearing is not required when a complaint shows on its face that venue was improper, which I think it has, and where there are no issues of fact to be resolved. On top of that, another case, Tropicana Products v. Shirley, Hurley, this is a second DCA case from 1987, specifically said that when a defendant challenges venue with an affidavit controverting the plaintiff's venue selection, that the plaintiff has the burden of proving the selection was proper. And an unsworn complaint is insufficient to create an issue of fact as it compares to a sworn affidavit.
It just circles back to Judge Rothstein Newcomb's point, which is that, well, give them a hearing, give them a chance to put on their evidence.
But there was no
discovery.
Yeah, the plaintiffs had over 2 months to present some type of evidence by way of affidavit or otherwise that would have controverted anything in our affidavit. And
what would they have gotten without discovery? All this, the information relating to where and whether or not JMAR does, customarily does business in Pinellas County or anywhere for that matter, is uniquely in the control of your client, right?
And Your Honor, I would just point to the litany of other cases in the state of Florida that no evidentiary hearing was required when an affidavit was filed in support of a motion and there was no controverted evidence by way of affidavit or otherwise in opposition to that. In fact, most of the cases cited in my brief, there's no evidentiary hearing because there's no factual issue in dispute. An evidentiary hearing is only if there was some type of evidence that their client had done this over a computer and had gotten the reservation that way or spoken to someone on the phone, then perhaps that would have been enough to require an evidentiary hearing. In fact,
wait a minute, that goes to my point, perhaps that you're talking about the reservation at the travel park.
Correct.
Well, I mean, but that goes to my point that it's not necessarily the business owned by the domestic corporation whose customary business must be conducted in the office. It's the business of the domestic corporation. So it's still the possibility that this domestic corporation owns a business that is operated in North Carolina, but it conducts its customary business in an office in Pinellas County.
And I would point to the affidavit of Ms. Welch, and there was some statements that they mention only an office, and that's not correct. Paragraph 7 says that JMAR keeps the only office they keep to transact their business, which is the rental of RP parks. That is their business, period. End of story, is located in Henderson, North Carolina. So I just because they have investments in their name, it doesn't mean that they have this investment portfolio under this corporation. The principal place of business listed on the Secretary's website is the North Carolina location. It's just the mailing address that is Pinellas County. The business is renting the RV spots in North Carolina and maintaining that land for renting RV spots in North Carolina. That's the business. So, I think that the statutes, this isn't the case of PricewaterhouseCoopers, where even then, with an international accounting firm doing business on computers in offices everywhere, over the phone, mailing things, even then it's not sufficient. Here you have a RV park that rents camping spots to RV travelers in North Carolina, and that's their only business. So again, there's nothing that's been presented that controverts that would warrant an evidentiary hearing on the matter. And I don't think the case law supports the need for an evidentiary hearing when there is no factual dispute. And there's no factual dispute between any of the allegations in the complaint or with my client's affidavit. And like I said, the appellant would have had over 2 months to present some type of evidence, and presumably they would have done some type of discovery on their own before then about where they wanted to bring the suit to do whatever they needed to do to establish if they really wanted to bring the case in Pinellas County. I would go back to the cases. There are two of them. One of them is a Premier Cruise Line case from the 3rd DCA in 1990 that dealt with a factual dispute, and it's whether or not travel agents that sold tickets in Dade County provided sufficient basis to have venue in Dade County. And there were affidavits filed by the plaintiffs saying, hey, we called these agents and they said they were located in this county and they're doing business for this company in Dade County. So this is not a novel issue. In that case, it didn't require any discovery. It just simply required some type of evidence that they conducted any type of business in a certain county, and that just doesn't exist here. So I don't think that the court erred in making a determination without an evidentiary hearing, because again, we don't dispute anything that is in the complaint, and the complaint's not sworn anyway, and all of the factual evidence is that my client does not have an office. Sorry. My client doesn't have an office in which they conduct their regular business in Pinellas County. And that's not to say, I think one of the things that's missing is that I'm not saying that my client can never be sued in the state of Florida and can never be sued in Pinellas County. It's just under these facts. If there was some kind of contract that they entered into and that required some type of service in a certain area, certainly that would avail them to a Florida jurisdiction. If they owned property here for some reason that was the subject of litigation, then they would be subject to venue somewhere in Florida. But in this case, where the cause of action is a trip and fall that occurred in North Carolina, it is not within the Florida statutes to allow venue to exist here. And even though there are no cases on point, I think that the closest one is the Pearson v. Wallace case, in which the court said there are going to be occasions where a company doesn't have an office anywhere. In Pearson, by the time the suit was filed, the company had dissolved. And so the court looked at the fact that there are no offices anywhere in the state of Florida for this company. And we can't figure out where the action accrued because of this plane crash. The only office they did have was in Flagler. And when the trial court said, well, you can bring the case in Flagler because that's where they operated when they did operate, or you can bring it in Volusia where the corporate president resided, the DCA said, no, both of those are wrong. The only place that you can bring the suit is where the cause of action accrued, right? Which makes sense, especially in this case where the cause of action accrued in North Carolina. I don't think that if a trip and fall occurs in North Carolina, any law regarding whether or not it's a dangerous condition or it's open and obvious should be under Florida law. It should be under North Carolina law, right? And what it would essentially do is allow that to happen. So in the Pearson case, what the court said is when there's no office and when there's no property subject to the litigation, the only proper venue is where the cause of action accrued. So I believe that gives the court guidance in this case and why it's the right result in this case, because the cause of action accrued in North Carolina.
There's no further questions. Thank you, Ms. Sisti.
Thank you.
Ms. Schneider, go ahead.
Well, I'll pick up right where Ms. Sisti left off. What she just made was a jurisdictional argument, and it's in direct contrast to Bristol-Myers Squibb. The reason the Pearson court said do go where the cause of action accrued was because it was in Florida. And so that's a venue argument. There, they had an option in Florida of where to go, where the crash occurred in Florida. And actually in Pearson, they never addressed the argument about the president living in Volusia County. They just saw that there was a place where the cause of action accrued, and that was in another county in Florida. So that was an easy transfer to another jurisdiction. And again, there's no case that says instead of finding that this venue is proper, you should just dismiss it outright altogether. And then also to Ms. Sisti's argument about there's no evidence it's an investment company, no support. Well, of course, as Judge Atkinson pointed out, their name is Jason Miller Investments. And the SunBiz shows that the same officers own other investment companies who own RV parks in Florida. And this is just like a family owning rental property outside of the state, where a property management company would manage the day-to-day property. You're exactly right, Judge Atkinson. The business of the company is the actual investment. The asset is the RV park. And the affidavit conflates those two because they do say Jason Miller Investments doing business as this RV park. So then they're able to say in the affidavit all of the things related to the RV park. They don't specifically say anything about the investment company. And the question would be, why would your mailing address, if all the business is conducted in North Carolina, why would the mailing address be in Florida? Because obviously things like bills or other notices to the company, those would then come to Florida. And if there's no business being done in Florida by the investment company on behalf of the RV park, why would the officers in Florida be receiving all of the mailing for the business? And it's because the officers, the owners, the family members who own or control the business of the investment company live in Florida, and that's where they do the business. And like Judge Lucas pointed out, it's more of a forum nonconvenience argument about that the courts have an interest and don't have an interest in hearing. The forum nonconvenience argument fails too. The only witness that they've put up so far in this case is a Florida resident. All three officers are Florida residents. The people that we would be going to for the 30B6, Florida residents. Presumably the documents that we would have would be in Florida. So we have an interest in bringing this in Florida State Court. We have the ability to compel the attendance of those witnesses and the documents. Majestic 2 just wanted to point out the distinction there. There was no officer or owner who lived in the county. The only connection to the county, Dade County, was where the registered agent's home was. That was the business address that was listed on the Secretary of State. So in that case, the court said just service of process is not enough to establish venue, because there the only connection was a registered agent. Deerfield, that was just an isolated incident of exchanging money in this one county. There were no other ties that the defendant had to that county. And then to go to the pleading issue that came up. Tribune said that the plaintiff does not need to plead or prove selection is proper. Rather, the burden of proving venue is improper is on the defendant to clearly demonstrate the venue is improper. And Tribune also said the facts alleged to be phrased as to render it susceptible to the interpretation that defendant has an office it uses for the transaction of customary business was enough. And of course, here we have the allegations that form the basis of our venue argument, that there has to be the transaction of customary business in this county because the officers live here and the business mailing address is here. Again, Judge Lucas was exactly right. Where would we have gotten the info to somehow contradict what was in the affidavit? It is uniquely in the court's control. We served discovery with the complaint. That was ignored. We asked for site inspection. That request was ignored. We asked the court for discovery. That was ignored. We only have to present contradictory evidence when an affidavit conclusively proves that a venue is improper, and that was not done here. Ms. Sisti said, you should have done discovery on your own before you even filed the case. We couldn't even get the insurance policy on this property before we filed suit. They were just totally non-responsive to us. So I'm not sure how we could have done discovery of their corporate officers. Certainly we couldn't call up their corporate officers or their employees before or after we filed suit to try to get an affidavit from somebody there.
Ms. Schneider, I need you to wrap up, okay?
And that was just my my last, the PwC decision and the second DCA, that did not allege that there were any ties to Pinellas. That was just about the cause of action and where that accrued. So that was another distinction I wanted to point out. But thank you so much, Your Honors.
Thank you all. You all have a very good day.